Let the city come.
Lordship.
City of madam.
How did you know? Lordship, short date may be fixed and my name is not reflected in cause list, Lordship. We have not received.
Say why you have been arrested?
Lordship,
Case diary on when?
9 February. Lordship,
Short date.
a short date may be fixed.
7 February.
7.
Item 2.
Petition of the banana.
Yes.
Here, my lord, the petitioner has approached this court, my lord. When the incident was occurred, my lord, he was a minor. And though he
This
was
is for
named in
this
the
is
FIR,
for petition.
Passing petition.
we are not the recalling of that proclamation, my lord. And there are 3 accused, my lord, now at present. The petitioner was a minor, he doesn't know he was in Bangalore. Now, in his respect, my lord, the case was kept in the file, my lord. Now he has come to know, now he has approached this to recalling of this warrant of arrest and proclamation, my lord. In the, your lordship may look in the charge sheet, my charge sheet, he was not implicated. Only accused number 1 was implicated. It's page 16, my lord.
No, whether he has been searched or not.
No, no, later on the honorable court has taken cognizance against him also, my lord. And the charge has been framed against him also.
Whether he was present at the time of framing search.
No.
Then
No.
how can the court below frame search against you?
No. Yes, my lord. That's why, my lord, that someone was issued, my lord. Then he doesn't know that someone was issued. Then the warrant of arrest, then later on proclamation. Then now, my lord, his case is
Heard Mr. Sinha, learned counsel for the petitioner, and also heard Ms. A. Begum, learned additional PP for the state respondent. In this petition under section 482 services, the petitioner pressed for recalling the non-violable warrant of arrest and the proclamation issued against him by order dated 2/4/2019. In session case number 47 of 2018 under section 341, 326, 302, 34 IPC. Where is the petition and the documents placed on record? Let notice be issued. Returnable on when, madam? Short date?
Short date.
First week?
First week. 7.
7. No formal notice is required to be issued since Ms. A. Begum, learned additional PP, appears and receive notice. However, extra requisite copy of the petition be furnished to her during the course of the day. Registry shall call for the scanned copy of the record from the learned court below. List accordingly.
All right.
Item 3.
Yes. My lord, I am challenging this complaint petition and the proceeding. Because of the fact, my lord, they have infringed my legal right. Legal right as such, because my lord, the loan agreement was done in Guwahati. The vehicle number is of Guwahati. I reside in Guwahati. And in the complaint petition, they have stated that I paid the amount. Some amount is balanced. I have made a categorical statement.
Where is the copy of loan agreement?
My loan agreement is with them, my lord. I made a statement, the loan agreement I made in Guwahati. But in the complaint petition, your lordship will find.
No, you showed the court the loan agreement.
Well, loan agreement is with them, my lord. They are not serving us. But in the complaint petition, your lordship will find my place is in Guwahati. They have given the address, page 12. Page 12, Ronak and Pooja, they are giving the address at Guwahati, Assam. And my lord, even they have not stated that loan agreement was done in Guwahati. They have not stated any fact. But in para 5, they have, in para 3, your lordship will find the vehicle number is AS01HC9415. It is of Guwahati. Page 13. para 3, AS 01HC 9415. The vehicle is of Guwahati. And my lord, at para 5, your lordship will find they have said the accused repaid some of the legal liabilities and debts. They themselves are admitting that I have paid some amount, but some amount is left. Is absolutely an outright a civil dispute, my lord. I have made a statement, I have made all the payment. And now 406, 420 cannot come into being, my lord. And my lord, in one judgment, my lord, the only thing how it is permissible to challenge a complaint petition outside the jurisdiction of this court, my lord, the court, my lord, Justice Gogoi, as he was in then, my lord, in Supreme Court in 2014, 9 SSA, has said the basic thing is that I have to show that there is a legal infringement of my legal right. Where I am showing, my lord, here they know that my agreement is in, my address is in Guwahati, vehicle number is of Guwahati. They does not disclose where is the loan agreement. In the whole complaint petition, they have not stated where the complaint petition was executed. And now in para 5, they have stated that I have paid some of the loan amount. If I have paid some of the loan amount, some amount is balanced, and I made a statement that I have paid the whole amount, there is something but dispute which has to be resolved by a civil court. This is only to harass me now, because I cannot run to Calcutta. They through issue of warrant, they want to, my lord, get hold of me and take the money. This is the new procedure adopted by all these companies nowadays. There are many of the cases are filed in Guwahati High Court. In everything they are filing it. They themselves say their office is in Chennai. They have done an arbitration award in Chennai. My lord, and in
Where is those document arbitration award?
award, my lord, here, my lord, I made a statement. Award, they have done it, my lord. It has not come to me. It has, they have made a award. I made a statement. That is, my lord, para 8. They said in the arbitration award, the arbitration clause, the venue of the arbitration was Chennai. They themselves say their jurisdiction is in Chennai. Now they file a complaint case in Calcutta. They don't say about the loan agreement. The vehicle number is of Guwahati. My address is of Guwahati. I have paid the loan amount. These are all, my lord, basic things for which legal infringement has been done. That is why I am before your lordship.
So where are the judgments?
My lord, judgments are there. Yeah. First judgment, my lord, justice. This is 2018 GLT. Then, my lord, 2004 9 SCC and 2007 SCC. And, my lord, this one, infringement of legal rights, 2014 9 SCC 329. This is the book. This is the book, my lord, 2014 9 SCC 329. That GLT, my lord, specifically said 2018 3 GLT page 321. That was the case of Bihar, my lord. And this one is Justice Gogoi's judgment.
We'll see. Oh, we'll reserve the order today. Heard, Mr. Or one thing we can do, we can issue notice today. Interim period, we can,
My lord, I can give this award also, my lord. This is in Chennai, they have done this, is the award. They have done in Chennai.
no, the question is that where the loan agreement was executed.
My lord, your lordship will see that they have done an arbitration in Chennai. They have filed a complaint case in Guwahati, Calcutta. And I have stated that the loan agreement was executed in, my lord, Guwahati. I made a statement, categorical statement.
No, your mere statement will not do unless you produce the document.
My lord, because it is with them, my lord, they don't serve us. But from the complaint petition itself, it shows, my lord, that the vehicle is of Guwahati. And my address is of Guwahati. Partly cause of action arises in Guwahati. Complaint petition itself shows, my lord.
Okay, we reserve the order. We'll examine all these judgments.
Because, my lord, if until unless if it is stayed, my lord, they will issue non-bailable warrant of arrest, and I have to run to Calcutta, my lord.
No, we'll pass the order shortly. Within 1 or 2 days.
Whether I will take the book, my lord, or your
You
lordship may-
can give the Xerox copy.
Xerox copy, I'll give the Xerox copy.
Next item.
Item 54. Sorry, item 4. Sorry. Item 4.
Wait, here my name is not shown, although Wakalafnama is filed, Lordship. Here, Lordship, the petitioner before Lordship is a lady, Lordship, she filed an application before the trial, before the court below, under section 127 for enhancement of her maintenance, Lordship. And that was rejected, therefore, she is before your Lordship. Lordship may kindly turn to page 14.
Why it was rejected?
On the ground that initially when the maintenance was granted in the year 2006, there was a compromise between the parties that the opposite party will pay 2,000 per month. Subsequently, the employer of the opposite party enhanced it to 1,000. That is from 2012, she was getting 3,000 from the opposite party. And from the year 2017, he stopped paying the maintenance loan. Now the trial court held that there was a compromise and the enhanced amount was given by the employer of the opposite party. So therefore, she is not entitled for any maintenance. And as in my understanding,
The question is whether there was any sense of circumstance or not
yes, it was
in
the
favor
year-
of
it was in
the
year
petitioner.
2000. It was initially granted in the year 2006, and since then price hike is there, and Lordship, she is unable to maintain herself, Lordship. Because
First, it was granted in the year 2006. What was the amount?
2000.
2000.
And
Thereafter,
now she filed 127 application in the year 2018.
18, and that
After
was
12 years.
dismissed.
Yes,
And how can the employer increase the amount?
because of mutual understanding, Lordship. And he was also paid. He did not raise any objection to that also. Because he knew that the 2,000 amount is not sufficient for maintenance of the present petitioner. And I have got one judgment of Lordship Kerala High Court where it is said that compromise between the parties cannot preclude the woman from claiming for maintenance under section 125.
Okay, all right. Heard Mr. A. Ahmed, learned counsel for the petitioner. And also heard Ms. A. Begum, learned additional PP for the respondent number 2. In this petition under section 401, 397, read with section 482, CRPC, the petitioner has put to challenge the order dated 9/7/2019, passed by the learned judicial magistrate first class of Ayapuri in MR case number 02 of 2018. This to be noted here that by the impugn order dated so and so, the learned judicial magistrate first class North Salmara of Ayapuri has dismissed the petition filed by the petitioner under section 127 CRPC for enhancement of the maintenance allowance. peruse the petition and the documents placed on record and also peruse the impugned order dated 2017. Let notice be issued returnable in 4 weeks. Step be taken upon respondent number 1 by registered post and also by usual process within a week from today.
Respondent lordship already appeared. There was a delay lordship in filing the revision lordship. And in last order, in the delay application, the lordship has directed the registry to reflect the name of the counsel for the respondent lordship. They already appeared.
No, that is in this condonation petition. Is it not required to issue notice here?
If they are represented, probably it will save time because this is under for maintenance only.
But in this petition, no Ukalatnama has been filed by them. How can we direct to?
Because in their presence, lordship had direct and they did not raise any objection to that, to represent in the present main appeal, main revision law. The direction was in their presence.
Wait. Is present. Okay, you will contact the advocate. We'll take it up after some time.
Because in delay application also, it took almost 2 years to serve the notice, so therefore I was paying.
Obliged, lordship.
Item 54.
Procedure 430, investigation. Lordship, I am an employee of the railway department. Lordship, we come to page 12. Lordship, there is an FIR which is in page 11. Thereafter, I was in charge of the luggage van. I was called during investigation on 14. Lordship, see page 12. May I read it?
Where is the FIR?
FIR is page 11.
Yes.
Now, in the FIR,
So what was the allegation against you?
there is no allegation, Lordship. I will read the operative part in the FIR. During search, 10 bundles of timber wrapped in gunny bags to be stolen were recovered from near SLR white bundles. Here, while 10 bundles of, on the other hand, 50 sacks of betel nuts were recovered from SLR generator. A person, namely Pankaj Gogoi, suspected to be counterfeit, but Burmese betel nuts were recovered from the power van and a luggage bag of and generator car. And a person, namely Dipankar Gogoi, 24, son of so-and-so, was found with the recovered sacks of betel nut suspected to be stolen, and he has been apprehended for smuggling them. Among the recovered sacks, the betel nuts, some sacks were found to be around 20 kgs and some were around 25 kgs. It is highly suspected that the recovered sacks of betel nuts are stolen and Burmese origin, and it is also suspected that all the betel nuts and the recovered timber wrapped in gunny bags were tried to be exported by cheating with fake documents. All the sacks, dried area and timbers wrapped in gunny bags, sacks were seized by so-and-so TRP Investigation Center. I therefore request to kindly register the appropriate sections. Now, Lordship, page 12, Lordship, see. I was in charge of the power van. My name is not there.
So the allegation is regarding smuggling of those timber
Timber and betel, Burmese
timber
betel nut.
and betel nuts suspected to be of Burmese origin.
That is the allegation. Page 12. I was in charge of the power van. Now, Lordship may read, I may read page 12.
Recovered from the power van only.
Power van.
This case there will be required.
Lordship, I'll just read. I have been called during investigation on 14/12/2023. That is my apprehension. I was directed to appear on 20/12/2023. I received the notice on 27th.
Whether you have appeared.
Lordship, because it was through senior divisional electrical engineer, but I received after the date of appearance, that is 20/12/2023. Therefore, I could not appear. I am willing to appear.
No, you have not asked to appear before them. You have been asked to provide the documents.
And no,
You see the subject matter of the letter.
yes, subject matter is for providing documents produced by the owner and of the seized exhibit. But Lordship, second paragraph, Lordship, would kindly see in the investigation done so far, it is revealed that Sri Ravi Sinha was in charge of the power van. Sri Subodh Kumar was in staff. In the interest of investigation above, Ravi Sinha and Subodh Kumar have to be examined in connection with the case.
No, this notice was not issued to you.
It was not issued to me, and therefore requested to inform the above named persons to appear before the undersigned on or before 20/12/2023 at 10 p.m. positively to examine them in connection with the case.
So, how can the timbers and the Burmese supervisor loaded in the power van without your connivance or your knowledge?
Lordship, actually, one other person, Dipankar Gogoi, was in charge. I was in charge of the entire power van, and moreover, the gunny bags were sealed, Lordship. So we do not generally seal. Every day, some bags come. So but I am willing to appear just because I knew about this notice after the date of after 2012,
Heard
2023.
Mr. BP Bora, learned counsel for the applicant, and also heard Ms. A. Begum, for the additional PP for the state respondent. Apprehending arrest in connection with Moyangal ZRPS case number 133 of 2023 under section 120B, 420, 379, 411, 471 IPC, it is section 33, 41, 42 of Assam Forest Regulation. This application under section 438 services preferred by applicant Ravi Sinha for grant of arrest bail. The above noted case has been registered on the basis of one FIR lost by one Konkon Das ABC. New Bongaigaon GRPS to the effect that on 11/12/2023 at about 9:25 AM, acting on a tip of he, along with staff, conducted search in the Kanyakumari Vivek SF Express down train number 22504 and found 10 bundles of timbers and 50 plastic sticks of betel nut being carried in the luggage brake and generator car. No, in the rear and front SLR and luggage brake and generator car. Mr. Bora, learned counsel for the applicant, submits that the applicant is the in charge of a power van of luggage brake and generator car of the Kanyakumari Vivek SF Express down train number 22504 and one Dipankar Gogoi was the, what was his role? This Dipankar Gogoi?
In charge of the that part, Lordship, in which the Burmese superis and was found. He was kept there in charge. I was in charge of the entire luggage brake and generator gun.
One Dipankar Gogoi was the in charge of that part of the luggage van. And on 14/12/2023, a notice was served to the Senior Divisional Electric Engineer Tinsukia Division for providing some documents and also asking also issue direction to the applicant and one Subodh Kumar for appearing before the IO on 28/12/2023 at 10 a.m. Mr. Borda further submits that the applicant is innocent and he is ready to join the investigation, and therefore it is contended to allow the petition. On the other hand, Ms. A. Begum, learned additional PP, submits that at this stage only the case there may be called for. Having heard the submission of learned advocates of both sides, perusal of the case there is found to be necessary, and accordingly it is provided that the learned additional PP shall produce the case there before this court on
27 to
27. Having considered the submission of learned advocates of both the parties and also considering the nature of accusation and the punishment prescribed for the same, this court is inclined to extend interim protection to the applicant till receipt of the case hearing. And accordingly, it is provided that in the event of arrest of the applicant in connection with case number so and so under section so and so, he shall be released on interim pre-arrest bail on his executing a bond of rupees 50,000 with 1/3 of like amount to the satisfaction of the arresting authority. The above privileges, however, subject to the following three conditions. Last condition, he shall not leave the jurisdiction of CJM Boyega.
CM Boyer.
The number 5 matters for admission.
An appeal against the judgment dated 12/10/23 of this page 26. Page 26, the impugned judgment. And the accused were convicted. Page 40, paragraph 32. Page 40, paragraph 32, under section 498A, 313, 511, 320, IPC. And sentenced, page, paragraph 38, page 41. However, considering all aspects and looking to the plea of leniency as paid for so and so, I instead of imposing the maximum penalty as provided. 11 sections were contained the convicts.
Okay. Heard Mr. B. Sinha, learned counsel for the appellants, and also heard Ms. A. Begum, learned additional PP for the state respondent. In this appeal under section 374 CIPC, the petitioners, the appellants, put to challenge the judgment and order dated 12/10/2023 passed by the learned Session Judge Karimganj in session case number 109 of 2017. Whereby the learned court below has convicted the appellants under section 498A, T13, 511, 328, 34 IPC, and sentenced them to suffer rigorous imprisonment for 1 year with fine of rupees 1,000 with default stipulation, and also sentenced them to undergo rigorous imprisonment for 4 years and with fine of rupees 5,000 with default stipulation.
And also sentence, my lord, other 4 years.
And further sentenced to undergo rigorous imprisonment for 4 years and also to pay a fine of rupees 5,000 with default stipulation under section
328,
3
28.
under section 328. But where you have mentioned in the cost title,
Yeah, question that is missing, my lord, sorry, my lord.
missing.
That part is missing, man. 4 years for this, your lordship may skip to, sorry. Look into
But
page,
you have to amend this cost title.
yes, my lord. Page 41, my lord. Page 41 is there. Page 41. The convictions are there, man.
No, that is in the impugned judgment, but your cost
Sorry,
title
man,
is silent
that
on
part
this.
is missing. The section that mentioning of sections are missing here. Only 498, yes, sections are missing. Or I may allow by hand, my lord, to correct this one.
No, that is not permissible nowadays.
Only to put the section only two sections. One is for 498A.
Under section 328 oblique 34 IPC. Peruse the petition and the documents placed on record. And the grounds, no, peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugned judgment and order dated 12/10/2023. Admit, let notice be issued to the respondents. Returnable in 4 weeks. No formal notice is required to be issued since Ms. Begum, learned additional PP appears and received notice. However, extra requisite copy of the petition be furnished to her during the course of the day. Rest shall call for the record from the learned court below. The appellant shall take necessary steps for amendment of the first title. List after 4 weeks.
My lord, the I is also there, one I. Means their custody, my lord, from the day of judgment.
Heard Mr. B. Sinha, learned counsel for the applicant. And also heard Ms. A. Begum, learned additional PP for the opposite party. This interlocutory application under section 389 CRPC is filed by the applicants for suspension of sentence and for enlarging them on bail. It is to be noted here that the applicants were convicted and sentenced to convicted in session case number Mr. Sinha,
My lord,
this type of casual approach in filing the petition
sorry, my lord.
has to be deprecated. Where the case number is in
Case
this,
number is session case number 119.
no, where you have mentioned in this IA,
You know, the page 2, my lord, by pass session case number 119 of 70. Page 2 is continued, my lord, from page 1.
109 of 2007. And sentence that as aforesaid, agor kita tato. Yes, madam.
After receipt of the notice, lordship.
No, notice they have not implemented informant as respondent here. Only state is the respondent. Okay. It is to be noted here that connected criminal appeal has already been admitted, and the records of learned court below has already been called for, and the interim pair of this this application will be considered after receiving the record from the learned court below. List of the 4 weeks.
All right.
Party number 6.
Wait, wait, wait.
May I please, Your Lordship? This email petition, Your Lordship, I had challenged the order dated 27 to 23. Fact of the case is that the petitioner, the learned CGM, Your Lordship, Dhubri, granted default bail to the petitioner, case 50, kindly bear with order. 152. One five years. But it is 16/8/2021.
Yes,
The default bail was granted due to not submit the charge sheet within the stipulated period of 90 days.
you have been allowed to go on bail.
Lost default.
Thereafter,
Thereafter, Your Lordship, the petitioner is unable to submit the bail bond. Subsequently, filed a petition and the independent case is committed to the learned session court, Your Lordship. After this, the petitioner filed a petition and on 27 to 2023, they allowed him to go bail. But by order dated 27 to 23, page 19, Your Lordship, kindly page the order. Impugn order, page 19. The petition was rejected. As per page 20 bottom, because Motorbike was granted bail after completion period of detention by Lanet Estate, could not furnish bail bond till filing of charge sheet. And thereafter, no bail order for the accused has been passed and the petition is empty.
yes, madam.
Reliable judgment of this Supreme Court has scored.
Lordship. The trial is already started. So there is default bail is there, but Lordship. Let the LCR be there, Lordship.
LCR has already been called
Oh,
for.
LCR is there, Lordship. Then,
That
Lordship, then we will go through, Lordship.
Bikramjit Singh and others in Supreme Court said once they did granted Your Lordship, and because it had court in then also in the round. Rakesh Pal case also said once bail is granted, default bail cannot be cancelled. It is an individual right of the accused in favor of the petitioner. Paragraph 2933 of the Bikramjit Singh case.
Lordship, at two, Lordship. I will go through, Lordship. Hmm.
29 page 642 and 33 648. Some other judgment also relied in this case.
It's not this. Was granted bail on 16/8/2021. Until 6/9/2021, he have not submitted the bail bond lordship. And then the charge sheet was submitted.
No, here also bail was granted,
Granted,
so you failed to
submit the
submit
bail
bail
bond.
bond. So how this judgment will help you, this
640,
Bikramjit Singh?
648 page, paragraph 33.
Hmm?
Once bail is granted, default bail after going to the lordship.
Where it is stated?
It's an individual right of the accused in favor of the accused that if default,
Hmm.
bail is, if investigation is not completed within the district.
No, you have granted bail,
They have
but you
granted
failed
bail,
to.
but
But the question is whether the order will remain in force after submission of charge sheet. That is the question.
it is the fault of the petitioner lordship. He have not submitted the bail bond lordship within that period.
Because once his bail is granted, if the default bail, he or she cannot be cancelled. Court instance also.
Okay,
Person order is
you
bail
go through
order.
the record. You
Lordship,
apprise this court.
lordship.
Item numbers 8 and 9.
Lordship, let it be on Tuesday, lordship.
No, today.
Item 8 and 9, bail hearing matters.
There is a lordship for 39 applications, lordship.
8 and 9.
Today is the 76th day, lordship, on 9/11.
My lord, we have received the case diary just now, lordship. Can it be with a voluminous case diary, lordship? Can it be tomorrow, lordship?
On lordship, it was received on 21/12/23, lordship. On that day also, they took time saying that this is
No,
voluminous.
that day, lordship, we have not received the case. We have received the case. diary today.
120th, it is recorded in the order. Case diary was there. On 21/12/2023, lordship.
No, madam, on 19/1/2024, case diary was not available.
Now, earlier, lordship, 21/12/2023, case diary was there, lordship. Due to they prayed for time because of this voluminous case diary, lordship. Lordship, today is the 76th day, lordship. And
Yes, Mr. Borua, can you
Take
go?
for tomorrow, lordship. Tomorrow, lordship. We'll require some time to go to the case diary.
Okay, tomorrow then. Let him go through the CD. Mr. Borua, RJ Borua, learned additional PP submits that he has received the case diary, but as it is voluminous, he could not go through the same. And price for listing the matter tomorrow. Here allowed. Resist and list the matter tomorrow. CD be written.
Item number 10.
Please, your lordship. My lord, this is 439 application, my lord. Fact of the case is that, my lord, after lodging the FIR, my lord, police has investigated the case, and after that, the charge sheet has been filed, my lord. On 22/6/2023, my lord, Honorable Court passed an order issuing warrant of arrest, my lord, to the officer in charge, my lord. And thereafter, the police executed the warrant and released on bail, my lord. After that, my lord,
Released on
released on bail, my lord. After that,
by
my lord,
police.
my lord,
He was released on bail by police.
Yes, your lordship, because my lord, the order passed by high dated 22/6/2023, bailable warrant was issued, my lord.
Acha.
My lord, after that, my lord, the petitioners appeared before the Honorable Court on 1st of September 2023, my lord, as the date of appearance was on 1st of September, my lord. The Honorable Court has remanded them to the custody, my lord. My lord, my humble submission is that as the petitioners appeared before the court on issuing process, my lord, the court should not remanded them into custody, my lord. Even then, my lord, the petitioners have filed a petition which was rejected, my lord. And my lord, since 1st of September 2023, the petitioners were behind bar, my lord. Now it is 144 days behind bar, my lord. My lord, in
So
this,
at what is the case is pending now?
my lord, evidence stage, my lord, one witness has examined, my lord. In this regard, I have filed an additional affidavit on,
Whether the victim woman has been
No.
examined?
no, my lord. My lord, as instructed my client, my lord, she is on, she has delivered a child, my lord, few days back, my lord, and she has not been appeared, my lord.
So let her statement
My
recorded
lord,
by
my
the
lord,
court.
here
My lord,
allegation is 376D, my lord,
my lord, kindly see the,
and 164 statement specifically implicated, my lord.
my lord, kindly see the medical report. I have annexed at page 28, my lord. At 25, relevant portion is at page, my lord, at page 26, bottom, my lord. Number 1, no evidence of recent coitus found, my lord.
But she has delivered a
No, my lord,
Why
it is, the allegation is 21, my lord. It's after losing the affair, she has married to some other person, my lord. And allegation was of 21, my lord. My lord, I have filed an additional affidavit bringing on record the statement of the witness who has deposed before the court, my lord. Hold on. She has stated, my lord, in her deposition that there was no such incident took place, my lord. My lord, I think
where that affidavit is?
affidavit is not on record, my lord. If I can supply copy, my lord.
No, when did you file?
Day before yesterday, my lord.
My lord.
Okay,
Regarding service also, my lord, here perhaps service also not completed, my lord.
My lord, in this
As per
regard,
official
there is a mark, my lord, that is X. Next page of the flag X, my lord, is stated on the above by putting a seal that return after service.
But no report is there regarding whether no report is, only stamp is there.
okay, we will call for the affidavit.
My lord.
My lord, kindly taken up this matter.
After
it be
few days,
tomorrow, my lord?
in the meantime, let the evidence of the victim be recorded.
My lord, it is fine. It is
My lord, in
necessary
this
to-
case, my lord, I want to withdraw this petition, my lord. My lord, as per order of the Supreme Court, my lord, bail petition have to be disposed of within 2 weeks, my lord. But
Yes.
already this petition has 2 months left, my lord.
Yes, you have the liberty to withdraw the
My lord.
petition. Okay. Mr. M. Soikya, learned counsel for the petitioner, submits that he has a instruction to withdraw his petition. Accordingly, this petition is now disposal on the thread.
Object, your lordship.
At number 11,
That is your lordship. 439 application lordship. Here lordship, the co-accused were granted bail by this honorable court. That your lordship will find page 83. And one of the accused is granted recently on 19th lordship. I have got that copy. On the ground that in the charge sheet, lordship, 56 witnesses were cited and only one witness examined till date. And Others will, there is unlikely of concluding the trial at an early stage also. In that case, he was arrested on subsequent, on 7/9/2022, and I was arrested on 6/8/2022, prior to him proceeding. I'm in more days in custody than. Just
So
I'm
therefore you were entitled to bail.
on parity ground. I'm just sending over the copy of that.
So this is the second bail application.
Lordship, second letter.
Yes, Mr. Sharma, have you gone through the
Yes,
record?
my lord, I have gone through, my lord. My lord, Perity may not come because, my lord, his role, my lord, I have examined his role, my lord. I have flagged mark all the important pages, my lord. He is the prime accused, my lord, in this case, my lord. The other are maybe granted bail, my lord, but they may not be on same thing. My lord will examine, my lord, I have his role in the search sheet, my lord, specifically the role of each and every person is mentioned, my lord. I have flagged marked the 11 pages of the present petitioner, my lord. I
Page-
think, my lord, that Perity will not come in this case because he
Page
is the,
66 and
he is
68.
the, my lord, UAP Act, my lord, on section 18, 19 and 20. All are, my lord, coming. My lord, he is one of the imam, he served as a imam in one masjid, my lord, in that area, my lord, Barpeta district.
Lordship may kindly say page 66. This is down below your lordship will find that Kazibur Hussain, who was granted bail against his involvement.
60?
And 66. He was granted bail. And my involvement, your lordship will find at page 68, at column number 10 top. My involvement much less than
Column number?
10, top, page 68. Abu Bakr Siddiq.
At 62, my lord, at page 62 also. 62, it is in details, page 60. His role.
No, Mr. Sharma, whether ABT is a banned organization?
My lord, yes, my lord. Is the ban organization not only in India, my lord, it is banned in Bangladesh also.
Is not notified.
So
to
is
my-
it in the UAP Act?
No, it is not there in the UAP Act.
Then on what basis you were submitting that?
My lord, it is search sheet, my lord, is specifically mentioned, my lord.
Answer of
What?
Bangla is related to
The
Bangladesh.
search sheet, my lord.
Where it is mentioned?
My lord,
They use the word affiliated to.
Yes.
Al-Qaeda.
yes, my
But
lord.
how they got come to know that affiliated to? See, that is that ABT is not banned in India. It is Ansarul
No, no, they are-
Bangla team. They were associated with Bangladesh lordship. They have nothing to do with this India. And they have not the central government has not notified that ABT is banned in India. That I have not come across. Subject to what my learned friend says.
Okay, Mr. Sharma, you produced the.
Yes, my lord,
document,
there
if any?
is the notification,
Okay,
my lord. I have-
we reserve the order then, you produce the
My
document, we'll see. Heard Mr. A. Ahmed, learned counsel for the accused, and also heard Mr. B. Sharma, learned additional PP. Argument concluded, order reserved.
Problem. And page 83, lordship, that other co-accused, they were granted bail. I have enclosed in my petition.
Uh,
And second, I have. Problem.
Item 12.
May it please your lordship, my lords, 439 application is lordship. city was called for, your lordship.
Yes.
So as on date, your lordship, I am behind the bar for 41 days, your lordship.
We have received the case diary.
Yes, what is the stage of investigation?
Well, it is pending for to more further investigation also, and there are some other accused persons who are not yet to be arrested also. There are some other accused persons, they are yet to be arrested, and it is pending for further investigation.
My lord, my lord.
Where is the FIR?
FIR is at page, your lordship, page 9, your lordship. Page 12, my kindly believe. Relevant is 12, page 12, your lordship. May I read, your lordship?
Yes.
With reference to the subject cited, I have the honor to inform you that the information received from the reliable sources that some people of Lahorigarh area have been engaged in the illegal activities of duping other people with false /force documents and taking online loans from various entities by providing fake documents. In order to do that, they prepared fake forged PAN cards, Aadhaar cards, birth certificates, etc., and also obtained SIM cards using those fake documents. The culprits are obtaining online loans from various entities, financial institutions by providing fake forged documents in the name of different persons to defraud the entities and not returning back the loan amount. Accordingly, on intervening night 12/12/2023 to 13/12/2023, along with staff conducted raid at various places under Lahorigarh Triage area and searched the house of the below named accused persons. During search, SIM cards, PAN cards, birth certificates, seals, and other incriminating items were recovered. However, two of the culprits, namely Firdous Alam, son of Hazrat, village so-and-so, number 2, Ashik Anwar, son of Javed Ali of village so-and-so of Lahorigarh Pier, managed to escape. The above recovered items consist of forged documents bearing some names issued from different entities. It has been learned that the accused person has been making some false documents and certificate counterfeit seals and using them as genuine ones to cheat various stakeholders by impersonation to illegally earn money on online fraud. So this allegation, lordship. So for allegation against me, lordship, neither I have approached before any entity, lordship, for availing loan, nor I have furnished any documents, nor any manufacturer tag document, nor have any nexus, lordship. And besides, your lordship, I am behind the bar for long 41 days, your lordship, and other co-accused persons already enlarged on bail. I have the copies, your lordship, and para number 6 of my petition, I have stated, your lordship. Though copy could not be annexed, your lordship, but rest accused persons, they are also enlarged on bail, your lordship. Okay. Maybe there are some other persons may be related to your lordship. Despite the fact, your lordship, most of the cases are already enlarged on bail. So I will cooperate with any conditions and condition I will be allowed to run. I will cooperate, your lordship. And that is also on medical ground. And we have also prayer of medical grounds.
So where is that document, medical document?
Medical is a lordship, because medical document was a call for your lordship. I have annexed one. Page 18 may kindly look into your lordship. And some prescriptions are there, your lordship, page 19 and 20. Page 19 to your lordship, 21. Page 18 to 20, 22, your lordship.
Okay. Heard Mr. A. Devan, learned counsel for the accused, and Mr. Arjay Barua, learned additional PP for the state respondent. This application under section 439 services prepared by accused Baharul Islam, who has been languishing in jail in connection with Lahorigat PS case number 300 of 2023 under section 419, 420, 466, 468, 471, 473, 474, 34 IPC, read section 66C, 66D IT Act for granting bail. The above noted case has been registered on the basis of one FIR lodged by SF Robinson Bora of Lahorigat PS on 13/12/2023. The essence of allegation made in the FIR dated so and so is that one Ghiasuddin Ahmed, Harun Rashid, Zahidul Haq, Faizuddin, Rakibul Hussein, Aruf Hussein, Abu Sahid, Wahidul Haq Ansari, and Baharul Islam are involved in preparation of forged document such as PIN card, Aadhaar card, birth certificate, seal, etc. And also obtain SIM card using those fake documents. And they obtain online loans from various financial institutions by providing such fake documents in the name of different persons to defraud the entities and not return the amount. And on the intervening night of, no, not necessary. The learned counsel for the applicant, on the accused, submits that the accused was arrested on
Arrested on 14/12/2023, Lord. Yes,
14/12/2023, and since then he has been languishing in jail as for last 41 days. Further, Mr. Devan submits that some of the co-accused have already been enlarged on bail, and that the accused is suffering from renal diseases and being admitted at Moregaon Civil Hospital and undergoing treatment. And therefore, considering the period of detention and also considering the medical condition, it is contended to grant him bail. On the other hand, Mr. R.J. Borua, learned additional PP, has opposed the petition on the ground that investigation is going on and the IO has collected materials against the applicant, against the accused. But having heard the submission of learned advocates of both sides, I have carefully gone through the record, petition and the documents placed on record, and also perused the case diary with the assistance of Mr. Borua, learned additional PP. It is not in dispute that the accused has been languishing in jail as of for last 41 days. Further, it appears that the accused has been suffering from renal diseases, and a report was called for from the Superintendent District Jail Moregaon by order dated 8/1/24. 8/1/24, and a report has been received from the Superintendent District Jail Moregaon, where it is stated that the accused is being hospitalized in Civil Hospital Moregaon since 9/1/2024, and he has been suffering from renal calculi and urinary tract infection and undergoing treatment there. Having regards to above and also having regards to the nature and gravity of the offense and the punishment prescribed for the same, and balancing the same with the period of detention, this court is of the view that further custodial detention of the accused may not be required in the interest of investigation, and accordingly, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one security of like amount to the satisfaction of the learned judicial magistrate Moregaon, the accused
This is my respectful submission is that, my lord, since it is based on documentary evidence, and I am a person who is willing to cooperate with the investigation. If I don't cooperate, my lord, they can always come for cancellation. The thing is that the subsequent person arrested, detained in custody, he could not produce any investigation or document before the IO to show that I have entered into an agreement. Then they will make up a story that I have taken the original agreement. Well, even if you have taken an original agreement, then you have to retain a photocopy. Then money receipt also they don't have. Well, if your lordship filters the emotional part from the FIR, the facts remains that 2003 they say is an agreement.
The
2008
emotional part or minus the emotional part, some materials are there against you. Your name is there,
Well, name is there,
Your
but it
name
is
is
not
uttered
supported by the
by-
documents. Madam.
uttered by the other witnesses also.
No, but they are all trying to justify this FIR, but they don't have a documentary evidence to sustain that. Madam, nobody will give money 75,000 without a money receipt. The first installment. Nobody will give a agreement if someone has an original agreement. He will not hand it over to the from 2003. He knows that this person is not giving the land. Then 2008 he will hand over the original agreement to that person, my lord. Those are there, but fact remains that, my lord, this at this stage, so far looking into the allegations made in the FIR and the scissor list, I respectfully pray that custodial interrogation may not be necessary so far investigation of the case is concerned. And I'm not at flight risk because after the grant of interim bail of this honorable court in the month of December 6th, I appeared before the court. I appeared before the investigating officer to record my statement, my lord. And I have not misused this liberty during this period from December 4th till today, madam.
Heard Mr. D.D. Gore, learned senior counsel assisted by Miss
Valentina Villabino.
learned counsel for the applicant and also heard Mr. Arjay Gurwa, learned additional opinion for the state respondent. Apprehending arrest in connection with Satgao PS case number 226 of 2023 under section 120B 406 420 468 471 506 IPC. This application under section 438 services prepared by applicant Latif Ali for grant of previous bail. The above noted case has been registered on the basis of one FIR lodged by one Sadhunandan Roy on 6/12/2023. The essence of allegation made in the FIR dated so and so is that one Latif Ali of Satgao, Guwahati has executed an agreement with him for selling a plot of land situated at Kolitakusi, covered by DUG number 170, Patta number 107 under the revenue village of Kolitakusi, Moza Beltola, and later on Latif Ali on several times refused to register the same, though he has received a sum of rupees 75,000. And thereafter, he entrusted the task to Nazmul Alam for execution of the sale date. And Nazmul Alam also took a sum of rupees 3,80,000 from him. And both the persons cheated him by selling the aforementioned plot of land to which none of them were the owners. Mr. Kumar, learned counsel for the accused applicant submits that the applicant was granted the privilege of previous bail by this court by order dated 12/12/2023 and pursuant to the said statement, said order, he had appeared before the IO and his statement is recorded. And that the matter relates to document and in support of the allegation, no money received, no sale deed has been produced by the applicant, produced by the informant produced by the informant, and he is ready to cooperate with the investigating agency, and his custodial detention may not be required in the interrogation may not be required in the interest of investigation, since he has been cooperating with the investigating agency, and therefore it is contended to make the interim order dated 12/12/23 absolute in the same terms and conditions. Whereas Mr. R.J. Borua, learned additional PP, has produced the case before this court and submits that I has collected sufficient incriminating materials against the accused, against the applicant, and the co-accused, namely Nazmul Hussain. Nazmul Alam alias Mon Chaudhary has already been arrested here in this case, and his bail petition was rejected by this court after perusing the case diary in BA number 4620/2023, and therefore it is contended to dismiss the petition. Where having heard the submission of learned, however, Mr. Borua submits that the applicant had appeared before the IO and his statement is recorded. Having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record, and also perused the case diary with the assistance of Mr. Borua, learned additional PP. It appears that the IO has collected some incriminating materials against the applicant, against the present applicant. But it also appears that the applicant has been cooperating with the investigating agency pursuant to order dated 12/12/2023. Further, it appears that the allegation relates to further, it appears that the matter relates to documentary evidence, and the same has already been collected. And in that view of the matter, custodial interrogation of the applicant seems to be not warranted here in this case, and therefore this court is inclined to make the interim order dated 12/12/2023 absolute in the same terms and conditions. Case there will be returned.
Timing 29.
We are deeply obliged.
Timing 29.
Lordship, Lordship filed under section Lordship 379/411, and the present petitioner name is not there, Lordship.
Lordship, I'm appearing for Mr. N.K. Kulkarni.
Search sheet is filed for Samuel Ali and Muhammad Jalil Ali.
Search sheet was submitted under section 379/411.
On Lordship, date Lordship 31/12/23, and CS number is 374/23.
The name of the present applicant is not there in the search sheet.
Lordship.
Heard, Miss, your good name?
Lordship P. Bodo.
P.
Bodo.
Learned Counsel for the Learned Counsel, appearing on behalf of
N.K. Kolita.
Mr. N.K. Kolita, Learned Counsel for the applicant, and also heard Miss A. Begum, Learned Additional PP for the state respondent. This application under section 438 services preferred by applicant Salam, who has been apprehending arrest in connection with Patasar Kusi PS case number 436 of 2023 under section 379/411 IPC. The essence of allegation made in the FIR dated so and so is that on the night of 1/12/2023, 500 meters of conductors of old 33 kV Patsala to Horupeta feeder has been stolen by some unknown person. The learned counsel for the applicant submits that the applicant was granted the privilege of pre-arrest bail by this court by order dated 28/12/2023 and pursuant to the said order. The applicant had appeared before the IO and he has been cooperating with the investigating agency and therefore it is contented to make the interim order dated 28/12/23 absolute in the same terms and condition. On the other hand, Mr. Begum, learned additional PP, submits that she has not received the case diary, but as per her instruction, the IO has completed an investigation and submitted charge sheet being charge sheet number 374 of 2023, dated 31/12/2023 under section 379/411 IPC. Against two accused, namely
Samul Ali and Muhammad Jalil Ali.
Samul Ali and Jamil Ali, and the present applicant has not been forwarded by the IO in the search sheet.
Sumol Ali. Sumol Ali. SUMA.
No applicant.
No, applicant is not.
All right. Sumal Ali and Jalil Ali, and the present applicant, namely Abdul Salam, has not been forwarded by the IO in the search sheet. In that view of the matter, this application become infructuous and accordingly the same is thence closed.
Pending item 33.
Yes, my lord, I have talked to my lord, OC my lord. He will submit the report tomorrow, my lord. And in the meantime, I have also received the case diary today. After a few minutes ago.
Acha.
Then matter fixed tomorrow, my lord.
Tomorrow.
Tomorrow, my lord.
Mr. B. Sharma, learned additional PP. Press for listing the matter tomorrow. They are allowed.
My lord.
Rest is list the matter tomorrow.
Okay.
37. I guess you was called for murder. I'm on interim.
She did not receive my lord.
Mr. B. Sharma, learned additional PP, submits that he has not received the case diary. Accordingly, it is provided that Mr. Sharma shall produce the case diary before this court on
16.
Dibrugarh. My lord.
16 February.
My lord.
16 February.
Till then, interim order dated 12/1/24 shall continue.
38.
He was called for lordship.
Actually, receive my lord.
I am paying for adjournment for the day lordship. In connection with this case lordship, I want to bring on record some relevant documents lordship. Can it be fixed on Monday lordship?
Okay, Mr. Ziuddin, learned counsel.
AK Azad. AK Azad.
AK?
AK Azad.
AK Azad, place for listing the matter on Monday.
On 29.
So as to enable him to bring on record some documents by filing additional affidavit where allowed. List the matter on
29.
Monday.
CD may be retained.
Till then CDB retained.
Item 39.
My lord, this is second bail application, my lord. Earlier bail application was rejected, my lord. My lord, FIR is at page 9, my lord. My lord, the facts of, so far the allegation in the FIR is concerned, my lord. The allegation.
What is the ground for filing this second
My lord,
application?
my view ground is that, my lord, during this period, my lord, police may have completed the investigation, they may have interrogated any other witnesses, my lord, because, my lord, the incident happened in the office place, my lord, in office premises, as per the FIR. From the office premises, she was called. So, my lord, and she did not mention any date time, but even then, it's said to be in the office premises. So, police may have recorded the statement of the persons who were in the office, my lord. She said that from office she was called out, and after that she was given some intoxicating substances, and after that she felt dizziness, and she was taken to some place, and the photograph was taken. So these were the allegations. So, my lord, the witnesses that were present on the office, if police have examined them, they may have narrated different versions, my lord. Because
Here, from the FIR itself, it transpires that my lord, it's a makeup case, my lord.
No, Mr.
My lord.
Sharma, we have already produced this statement.
My lord, it are
Statement is
rejected,
there,
my lord, after going to the case diary, my lord. In the order itself reveals, my lord.
My lord, my case is that.
Here
my
is
lord-
also no new grounds, my lord.
No, new ground is this, my lord. My case is that after this bail was rejected, police may have investigated the matter further and they have interrogated other.
So what is
witnesses.
the stage of
My
investigation?
lord, investigation going on, my lord, and he now the arrest, he is not yet arrested by the,
Pardon?
my lord, he is apprehending arrest, my lord.
So he-
Investigation is going on, my lord.
So police may investigate, interrogate other witness, my lord, in this case, after this rejection order. my lord. So some actual fact may come into light. Because this bail application was rejected in the month of August 2023. Nearly 5 months have passed. my lord.
So how the examination of other witnesses will
My lord,
improve your
why,
case?
my lord, I am submitting to you.
Because this kind of offenses usually take place within the four walls of a room or a house.
No, my lord, first thing,
Whether any independent witnesses are available.
no, I'm, first thing I'm submitting. my lord. The FIR, as per the FIR, she did not mention, they narrated
No,
that.
no,
no, I-
you cannot argue on the
No, no,
basis
I-
of that FIR because we have already
No, no,
heard you and
okay. It is
dealt with
in
the
that-
matter.
In that context only I am submitting, in that context only I am submitting. My lord, as per the FIR, the allegation happened 1.5 months before, no date was mentioned.
No,
But-
no.
I'm
You
taking- I'm just
cannot
taking the
argue
context.
on that point.
No, my lord.
You can only argue on the basis of new ground.
The new ground is that, my lord, the incident happened as per the FIR, my lord. She was called out.
No,
to the
no, but
office.
again, you can, you are again arguing on the point of this
No,
FIR.
No, I'm not arguing the point of view. My lord, my case is that, my lord, after the bail has been rejected, my lord, the police may have interrogated the persons who were present in the office on the certain day. Because on the particular date, she was called out from the office as per her own version. She was called out from the office and after that, she was given the intoxicating substance as per the FIR, my lord. So suppose in the office, a person is called out, definitely there may be some persons who will witness the incident. So if there is any such type of witness were examined, my lord, if such type of witness is examined, a person goes to the panchayat office. A person goes to the panchayat office and calls the president of the panchayat. She is the president of the panchayat, to my knowledge, madam. She is a president of the Gaon panchayat and she was called out. So during office hours, it has happened, my lord. During office hours, my lord. So my.
Okay,